The latest. Thank you for your love and support. I appreciate you all. They said the law was a cage for 60 years. They told us the keys to our destiny were kept in the vault of Paris, London, and Brussels. They thought the African court was a puppet show, and the judges were merely reading from a script written in London. But today, in the heart of the Sahel, a quiet room in Niamey just became the epic center of a global earthquake. Niger just didn't deliver a verdict. They delivered a declaration of war against judicial colonialism. Europe is trembling, and for the first time in their history, the predator is realizing the prey has become the judge. Professor Franklin Nyamson, the voice that the West tried to silence, warned them. He told the world that the judicial awakening was coming. He spoke of a day when African resources will no longer be stolen through legal loopholes and lopsided contracts signed in the dark. That day has arrived. This historic court verdict in Niger has sent a clear message. Our uranium, our gold, and our dignity are no longer for sale at a discount. If you want to do business in the Sahel, you will no longer look to the European court for protection. You will look into the eyes of African judges. Why is Europe shaking? Because for decades, international law was just a fancy name for European interests. When dispute happened, the case was flown to France or Switzerland. But Niger has broken the chains.
The decision of the Niamey court is a moral and spiritual lesson addressed to all the courts of the African continent, magistrates of Southern Africa, North Africa, Central Africa, West Africa, magistrates of East Africa. You do not need to wait for UN authorization. You do not need to wait for European Union authorization. You do not need to wait for authorization from the International Criminal Court, authorization from the International Court of Justice. You do not even need to wait for the authorization of the African Union to judge slave trade, colonial, imperialist, neo-colonial crimes suffered by each of our countries. You do not need to wait. That is what Niger shows. It suffices, based on the evidence of this crime, to take jurisdiction. One can judge and one can convict. The first important element here is that the curse is broken. No magistrate on the African continent will be able to hide behind their fear to say they cannot judge. The Nigerian magistrates have shown that it is possible. From this Nigerian jurisprudence, we know that there are in reality, but we knew it before, two kinds of magistrates on our continent. Magistrates crouching in the service of dictators and foreign interests, and valiant magistrates, priestly magistrates who speak the truth. Justice for African solidarity. I call those magistrates Maiatic magistrates, using the concept of Maat, which means, in the ancient multimillennial Negro-African language, well, truth, justice, and solidarity. It is therefore necessary that there rises throughout the continent African a new generation of Mahdic magistrates. MAATIC. Like the magistrates of the Niamey court. Second lesson. It is a technical lesson. Legal technique, scientific technique very clearly allows for the evaluation of slave trade crimes, colonial crimes, crimes of looting. For a long time, we tried to argue that these things, that belonging to a relatively distant past, it was difficult to evaluate and consequently to set the amounts of reparations. The verdict of the Niamey court is there. Proof of the epistemological power of African justice. That is to say that African magistrates are trained to scientifically constitute an objective judgment on slave trade crimes. colonial crimes and economic crimes that Africa has suffered. There is no scientific obstacle. The 6-point demonstration of this Niamey verdict proves it. The judges of Niamey do not have a training different from that of most African judges. They have the same intellectual aptitudes. Here, it is mainly a matter of trusting the African judicial intellect and implementing it. Second lesson, judicially, it holds up. It is logical, it is unstoppable. For example, the logical reasoning that says the agreements of cooperation and defense being unequal agreements cannot be considered legal and legitimate. This reasoning leads to immediate consequences, all the profits that foreign powers have made, and with agreements that consisted of imposing on us, having vassals at the head of our states, and then signing agreements with them, all the profits that foreign powers have made in Africa. Under these conditions, they are claimable by African magistrates. By African justice, we must pay Africa everything that we won behind its back by using vassals to plunder it. There is a third observation. What is very interesting in this verdict of the Niamey trial is that it is a verdict followed by practical application modalities. It is its practical character. First element, courage of the justice system. Second element, epistemological credibility. That is to say, on the intellectual level, on the scientific level it holds up. But there is a third important element, practical applicability. That is to say that Niger begins to reimburse itself from the assets of this power on its soil. That is art. First, everything concerning the exploitation of uranium is nationalized and it is a right. All the factories that were built by the plunderers, who did not pay, belong by right to the state of Niger, and any other asset that might belong to these powers condemned to pay belongs de facto to the state of Niger, on Nigerian soil. And there, this practical aspect of the tribunal's decision of Niamey is completely practicable by all African countries. There is not an African country whose soil is not strewn with assets of criminal powers of slave trading, colonial, neo-colonial criminal powers, powers that have committed crimes of pillage, all kinds of barbarism. Africa can amply pay itself without leaving Africa. Niamey teaches us that Africa can amply reimburse itself, but the judgment also applies to the debt, the famous debt that the judges of Niamey call the odious debt. But listen, why reimburse France, Germany, England for debts that were contracted by governments that themselves were subject to neo-colonial agreements? Leonine agreements. Why reimburse them when these powers have not paid for their slave trade crimes, for their colonial crimes, for their neo-colonial and imperialist crimes? Why repay them when these powers have not paid for the ecocide, the destruction of the African environment of which they are guilty so? The Nigerian decision is practical because that every African country can pay itself from the colonial debt. Every African country. When the magistrates convict, we can deduct that from the money France claims Niger owes it. We can deduct that from the money France claims that Cameroon owes it. All countries that have debts to slave trading powers, the colonial and neo-colonial powers, their judges, have a means of self-payment. No, we don't pay that anymore, that we don't pay anymore, that we don't pay anymore, that we don't pay anymore, until we arrive precisely at the 115 billion euros. The sentence pronounced by the Nigerian judges is divided into two parts. The first part consists of 85 billion euros for the uranium, which was looted on the basis of neo-colonial agreements. That is to say, agreements between France and itself. There are 20 billion euros required by the judges to pay damages for this looting. There are 10 billion euros required to help with health, with medical care, with the repair of the destroyed environment, during all these years of exploitation, and the sentence is accompanied by the nationalization of all assets of France, England, and Germany on Nigerian soil. That is to say that Niger begins to reimburse itself directly by confiscating everything that belongs to these three countries on its soil, especially since Niger considers that the agreements which have been signed since 1961 and not valid because they were signed under the constraint of the French neo-colonial dictatorship. These agreements do not bind the sovereignty of the Nigerian people, because they were not made by free Nigerians, by Nigerians freely capable of defending the aspirations of their people. These are forced agreements. They are therefore not valid. Consequently, the exploitation of Niger's uranium for more than 40 years is deemed illegal, illegitimate, and everything derived from it as profit must be reimbursed. The decision therefore calls for the seizure of assets, but also for the expulsion of all representatives of the three states concerned from Nigerian soil, as long as precisely total reparation is not made, and the decision entails the impossibility of any appeal. It is a decision that cannot be contested at the continental level and which cannot be contested at the level, for example, of the International Court of Justice or the International Criminal Court. Why? Because it falls under the sovereignty regained of the homeland of Sarau, Niamungu, Niger. These are the main ideas of the decision that the magistrates of Niamey have taken. We can now draw some consequences and some lessons for all the rest of Africa. The first lesson is the lesson of the courage of justice. The courage of justice. This decision by the magistrates of Niamey teaches all of contemporary Africa that our magistrates, as soon as they commit to defending our vital interests, to defending our peoples, can exercise justice with courage. What is going to happen then, now that the Niamey court has said this? Let us try to imagine the enemy's tactic. What will the neo-colonialists, the French imperialists, German and British do? It is important to imagine what they will do, because we are in a struggle. We are in a fight for African sovereignty. So, it is in our best interest to imagine what the adversary, or even the enemy, is going to do. First, you notice that they decided to bring the cases to courts where the judges are on their soil. They brought their conflicts, their disputes with Niger into French courts. When it is they who bring this to French courts, it is normal. So, on the international level, we must expect reciprocity. They will start opening proceedings against the Nigerian state in their judicial system. That is the first consequence. In any case, that is what Paris has started to do. All these Western states defend their multinational and they instrumentalize their justice to defend the interests of their multinational. Because the political elites who are in Western palaces have been financed by financial billionaires. The industrial billionaires of their country. The Western political elite is globally slave to the Western military-industrial financial system. Those who possess the finances, those who possess the industry, those who possess the defense and security systems, control the Western leaders. And at the same time, it is they who are behind the large multinationals, which are in reality today heaps company, pox, state companies. That is to say, that a multinational, I don't know, like Facebook, a multinational, I don't know, like Exxon or like Total or like Orange, makes decisions that do not depend on any state. We call them state enterprises, or state companies, in the style of the colonial East India Company in the 19th century. You must realize that in the West, politicians have lost power. The people have lost power. Power is in the hands of financial oligarchies, military and industrial. And these financial oligarchies military and industrial control the judicial apparatus. They will therefore launch opportunistic prosecutions against Niger and even against its leaders. We must expect it. The response to that will be equivalent prosecutions. They launch a so-called ban on travel against the leaders of our African countries. Each country that receives this ban launches the same travel ban against the leaders of the country in question. If we catch you in our sky, it's the same. We apply the same rule. They will therefore try to leverage their judicial system to trigger proceedings and sanctions against the state of Niger. We must expect this against all states that will engage in the judicial revolution of reparations. Second consequence, it follows that movement in the international space will be an extremely marked movement by the quality of international alliances. You saw the strategy they put in place to go capture President Nicolas Maduro in his country, in Caracas, Venezuela. This strategy augurs a world where grand state banditry will become the open rule, because it was the hidden rule of international relations. But now, it will become the open rule. So we must expect attempts at kidnapping operations, at attempts of assault, at assassination attempts. This we already know, against the main leaders of the Global South, and in particular those of the AES. Second consequence. Third consequence. What will they try to do? They will try to invent crimes against humanity, to invent war crimes, to invent economic crimes that they will try to attribute to the leaders of Niger, Mali, Burkina Faso, the AES, in order to destroy their image internationally. Now, we know, the method used by neocolonialists in these cases is the manipulation of ethnicities. We must be very attentive to the manipulation of ethnicities. For example, I see for some time now in Niger, the neocolonialists, and indeed French who try to exacerbate tensions internal around the question of languages. We must be very attentive to this problem in Niger and retort and respond intelligently and powerfully to this diversionary maneuver. One of the subjects I hear regularly about Niger. It is the manipulation of the linguistic question by the neocolonialists. All the national languages of Niger must be spoken. They must be respected as such. One can choose to consider as a working language or as an official language, a language that is no longer spoken. But this must not turn into animosity between us, because we are the same African people, and that the political West in disarray is in search of reason.
African solution to the African problem. AU, I hope you are listening. By asserting judicial sovereignty, Niger is doing the unthinkable. They are nullifying contracts that have bled the land dry for generations. Imagine the panic in the boardrooms of Paris. Millions of Europeans gone. Decades of influence evaporated. All because a few brave men and women in robes who decided that the law belongs to the people of the soil, not the masters of the sea. But here is the part that didn't see coming. This isn't just Niger. This is the alliance of the Sahel states, AES, like a pride of lions finally realizing their collective strength. These nations are building a legal fortress. Professor Franklin puts it clearly. This is the second independence. The first gave us flags. This one gives us the govern. If Mali follows, if Burkina Faso stands firm, the entire legal architecture of Africa will shift. The judicial awakening is a wildfire, and the dry grass of colonial influence is catching flames. The world is watching. Will the West try to sanction this justice, or will they finally realize that the sun has set on the era of the big brother? As Professor Franklin says, the truth is a revolutionary act. And today, The truth is being spoken in the courtrooms of Africa. Are you still standing with the awakening, or you are still sleeping in the shadow of the past? Drop a comment below with a flag of your nation if you believe Africa's time is now. Don't forget to like and subscribe, because the narrative is changing and you don't want to miss what happens next. This is the braveness of Africa, because Africa is saying enough is enough. We do not want to have masters. We want to be the bosses of our own selves. Enough of having people who come into the continent in the guise of we know. These courts, these international laws and international everything that isn't in Africa has never been there to protect or to benefit the Africa. Like we take the UN, for instance. We are only going there, like Dr. Arikana said, to represent matter. And when it's time for us to vote on their issues, they give us brown envelopes. We give them the power. Nothing has to do with Africa. And our voices are silent, and that is the reason to which they always tell us if they give us a veto power, like one representative from the United States of America said, it will make the council dysfunctional. And we ask these people, how? If our presence in UN doesn't make the council dysfunctional, is it the veto power that will make the place dysfunctional? So as Africans, our time is now. And if you believe in the revolution, you need to always make sure we come together collectively every day to push the message ahead. We are the only people that can create a narrative in a way that will change everything. Because with these people, everything that they have designed never was there to help you, the African, in any way. And if we want to get there and move out of the chains that they have created, then we need to start telling the story in our own way. We need to start telling our own stories. And this is the perfect move that Niamey has done. And we want every other person to follow suit. Together, we reclaim our power, and not with what the puppet always sit down to discuss. We are the only ones that can set ourselves free. United we stand, divided we fall. And united we keep standing forever and ever. The greatest enemy of the African is mental slavery. So let's decolonize ourselves from mental slavery. Let's keep sharing to educate our brothers and sisters. Together we make Africa great for ourselves and the next generations that are going to come. So that's the latest around the world in Africa, West Africa, in Niger.